Hello, everyone. Daniel Sherman here. I want to talk today about Kentucky sentencing. Um, Kentucky has a 1 to 5, 5 to 10, 10 to 20, 20 to life statutory framework. When it was initially adopted, it was copied the New York Penal Code. New York has since amended their penal code to make the sentences less. We have not. So the offenses, I guess, in order as follows. You can have a violation. It's going to be like a traffic ticket. That's just a fine only. The next level is a B misdemeanor that carries 0 to 90 days in jail, up to a $250 fine. Then you have a Class A misdemeanor, which carries 0 to 12 months. My cats, by the way. 12 months in the county jail, up to a $500 fine. Then you have a Class D felony, carries 1 to 5 years in prison. Class C felony carries 5 to 10 years in prison. Class B felony carries 10 to 20 years in prison. And then a Class A felony carries 20 to 50 or life. And then you have murder, which is 20 to 50 or life, and then can be a capital offense if there's an aggravator, which can carry either the death penalty or life without parole after serving a minimum of 25 years. So that's the basic statutory framework. The real issue people run into is, what do these sentences have effect on my time serving? And I think if you're going to be an effective criminal defense attorney, you have to know the parole system, and you have to know what the eligibility standards are. And frankly, I've learned more from my clients that have been through the system than I've ever learned practicing or reading a book or anything like that. So there's a lot of my clients that have been through the system and they know it in and out. But there have been some recent changes in parole eligibility, so I kind of want to talk to you about that. For the last 15, 20 years, Class D felonies, as long as the aggregate was no more than 8 years, we're at 15%. That has changed starting February of this year. All Class D felonies are 20% now. Class C felonies 20%, Class B felonies 20%, unless they're considered violent offenses. And we're going to go through that. So what does that mean? The 20% rule just means you're parole eligible. So if you receive a 5-year sentence, then assuming it's just a regular offense, a nonviolent offense, you would have to serve at least 1 year before being eligible for parole. Now, the way parole works is they look at you, they make a decision on you 60 days before your parole eligibility date. So if you get a 5-year sentence, 12 months before being parole eligible, at that 10-month mark, parole will look at you and you should have a decision as to whether or not you're going to be paroled, and that lets you get things in order like your home placement and things like that. So now there are some times where some people say if they receive a shorter sentence of, like a year, they are in what's called override. Say if they've served 5 months in jail pre-trial, they're immediately eligible for parole, so parole will move them to the top of the list. And obviously they won't get that 60 days notice. Usually it's within a few weeks after their sentencing. So that's called override. And that is when somebody is within that 60-day period after they're sentenced. And it happens, if you take a 1-year sentence, sometimes a 2-year sentence. Now, what do the sentences mean? So I'm going to talk about nonviolent offenses because they're a little bit easier. When it comes to parole eligibility, you are given a minimum date and a maximum date. So your maximum date never changes. So if you receive a 5-year sentence, your maximum date is going to be 5 years, no matter what. That minimum date is always subject to change. So when they give you your minimum date, they're going to assume that you get your good time credit. Now, your good time credit, depending on the institution, is usually 7 to 10 days every month that you can get. Just don't be a jerk. Just follow the rules, and you will get that knocked off your sentence. And the typical time to serve 1 year, if you're serving it out, is 7 months and 21 days. So you can do the math on that. So that would be your minimum. Now, your minimum can decrease if you do a program, if you do parenting classes, if you get work credit. There are things that you can get to reduce that. And so when you think about taking a sentence, one thing you want to look at is, what is your parole eligibility? If I'm going to serve a sentence, when am I going to be eligible for parole? When am I going to serve it out? Sorry, my cats are being cats. And that's something you do have to consider. You also have to consider is some other programs that the DOC offers. DOC offers something called MRS, which is Mandatory Reentry Supervision. That was a program instituted under it was Governor Patton, and basically said, look, we need to let people go if they're a certain period of time from serving out their sentence. So that's a serve out, that's not parole. And so 6 months from being serving out your sentence, you were automatically eligible for MRS. Well, that used to be no matter what. So if you had a 1 year sentence, MRS, 6 months, you're basically in and out. You're in there for 30 days, and I had clients do that. That was changed to where you have to have more than 2 years to be eligible for MRS. And more than 2 years, for me, is 2 years in a day. That's more than 2 years. So I've seen a lot of times I will structure a plea agreement, 2 years in a day. My client just go ahead and serve it out because they know they're going to get MRS. But if you get 2 years, you don't get MRS. So the worst sentence you could possibly get, in my mind, is a 2 year sentence. You'd be better off taking a 3 year sentence because you get MRS, and you'd be eligible for what's called HIP. That's the home incarceration program. That's an ankle monitor. That'll knock another 3 months off your sentence. So, I mean, you could serve a 3 year sentence out with MRS and HIP about 4 months before you would serve out a 2 year sentence. So it's kind of, why would you take a 2 year sentence? So that's why a lot of times we'll structure a sentence as 2 years in a day. So that's one good thing to know. And then again, your minimum date can come down. Depending on whatever programs you do, a SAP program and things like that, it will come down. I do have, when I did work at the Kentucky State Penitentiary, I can tell you all my clients over there, none of them had their good time. They all lost their good time because they were always fighting. They were always bringing stuff in, and you kind of had to survive. It's a maximum security prison, and there was a lot of stabbings going on there, a lot of fights, and so I don't think I had a single client that had any good time. So 5 year sentence, it was a 5 years. There was no good time. Now, good time, a lot of times it's restorable, so you could possibly earn that back, but unless you're serving a pretty long sentence, you're going to lose it. They usually don't get it back. So as far as restorable and non-restorable to good time, that's just for a different discussion. But just want to let you know that when you're serving a sentence, that is something you have to consider. Now, as far as parole eligibility, again, it's 20%, but there's a few changes that they have made. I'm going to address that in another video. We now have 50%. They've made a lot more offenses, violent offenses, made them 85%. So that makes things a lot more difficult, a lot harder to advise clients. And they've made even, some class, some lower class C felonies and class D felonies violent offenses. So it makes it very difficult to advise clients. But the basic sentencing structure is the 1 to 5, the 5 year increments. Um, and the parole eligibility for all nonviolent offenses is going to be 20%. If it's Class A, it's an automatic violent offense, so you don't have to worry about that. So you're only looking at on most Class Bs, and I'll go over some of the exceptions on the Class Bs as far as what are violent offenses, because they're defined in the statute very specifically. Like, these are violent offenses. So I'll go over that in the next video, but just wanted you to know that when you take a sentence, you need to understand the way parole works, the parole eligibility system, your minimum dates, your maximum dates, because it has a lot of bearing on what you're going to do. I have clients a lot of times, hey, you're offered probation after serving a few months. And sometimes I look at them and I'm like, you're not going to survive probation. You just need to, take the year and be done, or take 2 years and a day and serve it out. And, 14 months minus 6, 8 months, you're out. So why would you do 6 months and then probation? I mean, why would you do that? Just take the 2 years and a day and move on and be served out. Now, again, if you take a year, you're not going to get MRS, so you're 7 months and 21 days. But, the way they release you, though, they release you on the first of the month. So if you're eligible to be released on the 29th of the month, then you get released on the 1st. And it's usually that first Friday is when they'll release you. Just so you get some people, oh man, I fell on the 2nd, so I don't really get much of a break. But, I fell on the 29th. I had one client, she went in, I told her, I said, take the revocation, go in, you're going to be out. She was out 3 weeks later on a serve out. So, very important to understand parole. Speak with your attorney. Unfortunately, I find a lot of attorneys don't really know the parole system as well as they should. It's something I've kind of prided myself in, that I have to know, because it does make a big difference in advising clients. You need to know it. They need to know it. And I don't really think you can do a service as an attorney without knowing all the ramifications of a sentence. And that's even with cases that, people are going to take probation, because you have to look, hey, look, if something happens and your probation is revoked, here's what you're looking at. We'll have cases, and, there was Hopkins County was kind of famous for this a long time ago. They would, we'll give you 20 years, but you'd be probated, or, take 5 years and serve. And people, you're going to take the 20 years. You don't want to go to prison. And then when you mess up, you're, oh my God, now I got to, serve 4 years before I even, look at anything. Well, if you'd taken the 5, you'd have been out in a year, and parole would have been a lot, easier. And one other thing you kind of need to know when you're paroled, like, that counts as your sentence. So if you're paroled, if you get a 2-year sentence and you're paroled after, 4 or 5 months, you go out and you're only serving the 2 years, and you're serving it on the streets, and you're getting good time, and it's just like you're incarcerated. So that is, something to consider. I really encourage clients to look at parole more seriously than probation, because probation it's more onerous. It really is. And if you mess up, you don't get any of that time on the streets. You catch a DUI, and I've seen it, people 4 years, 11 months into probation, go catch a DUI. I've had clients where, they had gotten in trouble before. The probation officer never reported it before they're off probation. The Commonwealth attorney looks at their records and says, oh my God, you had 2 DUIs. We're going to revoke your probation, because, you violated the terms, and a DUI is almost an automatic revocation. And then you're losing all that time you spent on the street. But that's not true with parole. As long as it's not a felony violation, and as long as it's not an absconding. And the date of absconding would be, you get time up to the date of absconding. And so that's something when you think about probation and parole, you really, really have to consider. So hopefully this has been somewhat educational. I will do a video on violent offenses and some of the good credit that you may be eligible for, that you may not be eligible for, some of the new statutes, and kind of what ramifications that has, because it's affected a lot of people, and I don't think a lot of attorneys have, maybe not up on it, because this stuff is brand new. In the last 2 years, they have changed the sentencing ranges and the parole eligibilities on a whole myriad of cases. So it's you got to keep up with it, and so and you also have to understand, parole is typically retroactive because it's not a right. So you can have something where somebody, I advise a client, hey, look, man, you're at 20% parole eligibility, and then they pass a law, oh, now you're 50%. I'm sorry. This is what I had one, the other day. It was a criminal abuse case. It was a 20% parole eligibility. I had to tell him, I said, look, you're 85% parole. Now, I do think that you're eligible for probation, because I don't think it's something the legislature can take away. But at the time of the offense, it was 20%. Now it's 85. They're going to make it retroactive. So you have to really watch that, because you may take a deal and then it may turn out your attorney tells you one thing and then it turns out it's completely different. So that's why you got to kind of keep up on it. So hopefully this video has been informative. It's gone a little longer than I hoped it would. Some of it was me just kind of rambling, but it can be complicated. But if you guys have any questions, just hit me up in the comments, or call my office. My number's on my Facebook page. I'll be happy to sit down and talk. I love talking about stuff like this. It's interesting to me. It's what I do for a living, and be happy to help you guys. So take care.